Welcome everyone to the 2026 licensing season Municipal Clerks Workshop presented by the Division of Alcohol Beverages. My name is Ann DeGarmo. I'm the supervisor of the Education and Outreach Unit. Here from our division, we have Caitlin Giddings and Meg McCullough, who are a part of my team. If you've ever called or emailed the Division of Alcohol Beverages in the last couple of months at doralcohol@wisconsin.gov, they are the kind voices and faces that are on the other end of the line. So I'm grateful for them to be here. They're going to be monitoring the lobby and just making sure that folks can continue to join us as this webinar proceeds. As a reminder, we asked for questions in a Microsoft form in advance of this presentation. We're not taking live questions today. So if you could please disuse and not use the chat feature, that would be wonderful. It's really distracting as a presenter, and especially when this is going to be a resource that's recorded and placed online. The faster I can get this recorded for you and placed up online, the easier it is. And certainly when I'm distracted, it's not ideal for those purposes. So thank you so much for respecting that. If you have questions, there will be other methods with which you can contact the division after the presentation. With that, let's get started. First, just our standard disclaimer. The purpose of this presentation is to promote a general understanding of the laws governing alcohol beverage regulation in Wisconsin. The presentation is not to provide administrative or enforcement determinations on specific facts or circumstances. If you need assistance in applying the concepts in this presentation to a specific set of facts, certainly consult with your municipal attorney. This is what we're going to be covering today. First, we're going to talk some general background that's necessary for clerks in order to do their work on licensing season. We're going to talk about our updates for 2026, and we're also going to discuss any reminders for 2026. We have a couple of exciting announcements and updates for you with our On the Horizon section, and we did receive a few questions that we have answered that are related to the webinar today. So we will get to those at the end. Again, just noting that this webinar is going to be posted on the DOR alcohol beverage landing page by the end of the week, provided everything in this recording goes well. First, we'll start with licensing season background. So just wanted to touch on a couple of important definitions. First and foremost, we have the overarching umbrella term alcohol beverages, which means that we're referring to any beverage containing at least 0.5% ABV, and it includes fermented malt beverages and intoxicating liquor. Alcohol beverages must have at least 0.5% ABV in order for them to be regulated by the Division of Alcohol Beverages and under State Statute Chapter 125. If a product does not have at least 0.5% alcohol by volume, it's unregulated, at least by Chapter 125 and the Division of Alcohol Beverages. We oftentimes, particularly starting last year, and we're starting to get them into this year with questions about THC drinks. If those beverages do not have 0.5% alcohol by volume, they are unregulated and untouched by us. So hopefully that heads off some questions. Certainly, you can consider regulations of those products at your local municipal level, but at this point, it is outside of the purview of the Division of Alcohol Beverages unless it has at least 0.5% alcohol by volume. The next category that makes up alcohol beverages are fermented malt beverages. These are commonly known as beer. This also includes fermented sugar-based hard seltzers and some wine coolers. Fermented malt beverages, or FMBs, are historically a very large category of beverages. And I would say if you have questions from temporary licensees or licensees about what types of products can be sold, their wholesalers are a great place to lean on because they are familiar with the labeling and the intricacies in the differences between these types of products. So know that fermented malt beverages is a much bigger category than most people expect. There's a lot more products that are included in fermented malt beverages now, with Act 73 changing the definition of fermented malt beverages. So a lot more excitement to be had in fermented malt beverages than years past. Secondly, the second largest category in alcohol beverages are intoxicating liquor. This is a broad term. It includes distilled spirits, things like tequila, bourbon, vodka, anything that would be made through a process of distillation. And then it also includes wine, which is things like champagne, sparkling wine, still wine, and hard cider is also considered an intoxicating liquor. Wine and hard cider are subcategories of intoxicating liquor. Wine can be sparkling or still, and wine also includes hard cider. Hard cider, as the subcategory of wine, is just where the alcohol is made from fermented apples or pears. So intoxicating liquor is definitely the more complicated category with several different subcategories. And I have a visual for you to help understand it a little bit better. As you can see here, alcohol beverages are the umbrella term. The thing that all of these beverages have in common is they have at least 0.5% alcohol by volume. There are two subcategories of alcohol beverages, intoxicating liquor and fermented malt beverages. That's the next line here in this chart. And then moving down in the category of intoxicating liquor, we have distilled spirits and wine, and then hard cider is considered a subcategory of wine. Next, we're going to talk about the different types of alcohol beverage licenses. Throughout Chapter 125, if you've looked at it recently and in any communications or published guidance that you'll see from the Division of Alcohol Beverages, there's a lot of quotation marks all throughout our guidance in the chapter. Those quotation marks are with purpose. If the quotes are located around the entire phrase, Class A, from the beginning of the class to the end of the A, that is an intoxicating liquor license. That's what that means when we're talking about Chapter 125. If there are quotations just around the letter, that is a fermented malt beverage license. So the quotations are with purpose, and hopefully this is a helpful trick and note to help you understand better the communications with the division and also our published guidance. We have two categories generally of regular retail alcohol beverage licenses. Class A licenses, think of those as Class A away. Those are for off-premises consumption. We're talking generally any store that's going to sell alcohol beverages in original unopened package for consumption away from the licensed premises. So we're talking grocery stores, convenience stores, liquor stores, anywhere where you would go buy packages and, for example, bring them home to consume in your home. Class B, we're always looking out for better ways to shorten this. So if you have creative ideas and ways that you remember what a Class B license is for, imbibe here is what I have here, but certainly if you can come up with a better one, we're open to changing this nomenclature. But Class B licenses actually authorize on and off-premises consumption. These are the places where you're going to walk in and want to have a drink, probably in a glass or in an open can or bottle that you're going to consume at the licensed premises. Typically, when we think of Class B licenses, we think of bars and restaurants. There are other types of businesses now that have and hold Class B licenses. And I will also note too that Class B licenses do authorize off-premises consumption of alcohol beverages in containers for consumption away. Class B beer licenses always authorize off-premises sales of beer. Class B licenses also always authorize some off-premises consumption of wine, and then your municipal ordinances will guide whether or not off-premises consumption or off-premises sales of distilled spirits is allowed. Finally, we have the one license, of course, with Chapter 125. There's always one exception to every rule. Class C licenses authorize on-premises consumption of wine only. There's no off-premises consumption of wine on a Class C licensed premises, but I will also point out when we talked about our quotation marks, the quotation marks around Class C are around the entire phrase, which indicates that a Class C license is an intoxicating liquor license because wine is considered an intoxicating liquor. So these are the types I know you're probably very familiar with them, but hopefully we've given you a couple of extra tips and tricks to keep the differentiations between these straight. Next, we'll talk briefly about temporary alcohol beverage licenses. Temporary Class B picnic licenses, as we call them, authorize sales of beer or wine only, and they are for consumption on the premises at a limited duration event. We will note that distilled spirits, even if those distilled spirits are in cans, are prohibited. It's just beer or wine. And as we discussed, wine is a separate category from all of intoxicating liquor, which is not distilled spirits. This is another one where, particularly around temporary licensees, if you have folks who are asking what types of things can I sell, you're going to want to direct them to their wholesalers. They have a good grasp. But generally, a trick that I keep in mind when I'm thinking about distilled spirits is that according to federal labeling standards, if a product has distilled spirits in it, it will have the name of the distilled spirit on the can. So if it says vodka, tequila, bourbon, any of those alcohol beverage types, if it's the name of a distilled spirit, for Wisconsin purposes, it's a distilled spirit and cannot be sold under a license that doesn't authorize sales of distilled spirits. Only certain groups qualify to hold temporary alcohol beverage licenses. We'll talk more specifically about these categories, but we're talking about bona fide clubs, chambers of commerce, churches, lodges, societies. I would say overarchingly, the common theme amongst these licensees is that they are generally not-for-profit. Being a non-for-profit does not qualify you to hold a license, but the types of organizations that are qualifying organizations tend to be not-for-profit. So keep that in mind. And nonprofits are considered corporations, non-stock corporations, typically license qualification purposes. The qualifying organization or group does not have to be located or based in your municipality in order to get an alcohol beverage license, a temporary alcohol beverage license. If the event that they are intending to host is located in your municipality, they would be correct in coming to your community to get a license to authorize that activity. And there are 3 forms that are used in the process of applying for temporary alcohol beverage licenses: AB 220, AB 100, and AB 101. Next, another general reminder, we're talking about minimum qualifications. State law prescribes a minimum set of qualifications that each person that applies for an alcohol beverage must meet. We are going to start with explaining how they apply to sole proprietors, because the way state law contemplates them is that it is first applied to individual people, just a human. So in order to qualify for an alcohol beverage license, a person must be at least 21 years old, there isn't like a great way to describe this, so we say acceptable criminal history and not be a habitual law offender. Ideally, we want people that are upstanding members of our society and who are doing the right things as it relates to this regulated product. But we also understand and acknowledge that sometimes people make mistakes and things happen, which is why when we're talking about criminal history or being a habitual law offender, that provision is subject to Wisconsin Fair Employment Law. And we're going to talk in more depth a little bit later about how Wisconsin Fair Employment Law applies to criminal background. I just bring this up now to say that criminal history isn't as straightforward as many folks think it is. We have options and tools that folks can use in order to obtain alcohol beverage licenses and operators licenses, that having certain types of criminal history doesn't automatically disqualify you from holding a license. There are some qualifiers there. The next is that an individual person must be a continuous Wisconsin resident for at least 90 days. They must also provide proof of a seller's permit for collection of sales tax unless they are otherwise exempt under state sales tax law. And then they also must pass a responsible beverage server course. And that is true unless they're renewing a license, in which case the renewal of that license serves as proof of passing the responsible beverage server training course. We know in these times that the age of the sole proprietor and the single business owner are sort of have come and gone. I know that there are some sole proprietors out there in many other areas in some of the more rural parts of the state, but if you're in an incorporated area, if you're in a big city, a lot of folks are involved in some sort of business organization to facilitate their business being run. How the qualifications apply to the people that are involved in a business organization depend on how that business is structured. So if you have a partnership that's applying for a license, all of the partners must meet all the individual qualifications we just discussed, but the partnership itself must provide proof of the seller's permit. Then we move on to corporations, LLCs, nonprofit organizations, cooperatives. These are all business entities, so they must appoint an agent in charge of the licensed premises who's going to essentially be responsible for the activities going on there. The agent that is appointed must meet all of the individual qualifications, and the officers or directors of a corporation or nonprofit and the members or managers of an LLC must be at least 21 plus and have a suitable or acceptable criminal history. 1 second. Then we're going to talk about forms. So, for alcohol beverage licensing purposes, there are 3 forms we're going to highlight for you. First, municipalities must use state-provided alcohol beverage license forms or a replica of those forms. The first form that we have for you is called AB 200. It's called the Alcohol Beverage License Application. It is created to comply with Chapter 125.043A. And generally, this form is required for all license applicants, even renewals. This is the form that captures your very basic information relating to the business entity, the identifying information for that business entity. They're going to describe their premises. They're going to identify the people that are involved in their business using this application. It's really the most fundamental form that is created for this purpose for all of your use. The next form is AB 100. That's called the Alcohol Beverage Individual Questionnaire. And the purpose of AB 100 is to capture the individual information relevant to determine your qualification under the minimum statutes in Chapter 125.045. So this is to facilitate identifying criminal history, establishing residence, and capturing essentially the contact information of the people that are involved in an applicant business that's using AB 200 to apply. So, and this year, all initial license applicants are going to be required to use AB 100. This has been true for a very long time. The name of this form has changed, and the look of the form has changed over the last few years, but essentially the spirit and the purpose of the form has not. So all initial license applicants need to use AB 100 to identify the people that are involved in the applicant business. This year, we've created an abbreviated or a quicker renewal path for folks. So renewal applicants are still required to use AB 100, but it is possible that a previous year form could be provided if all the information still contained on this form is accurate. And then finally, we have AB 101, which is the Alcohol Beverage Appointment of Agent. This form is created to facilitate LLCs and corporations appointing an agent per state statute. And that's because a corporation or an LLC is not a natural person. They can't take responsibility for that premises themselves. So again, this is specific to corporations and LLCs. When I say corporations, I'm talking about nonprofits, cooperatives, and other sorts of business, even nonprofit, non-stock corporations, and LLCs. So if you have a sole proprietor or a partnership, they do not need to appoint an agent. It's, again, very specific to corporations and LLCs. And certainly if this is an initial packet that you're receiving, from one of those types of entities, AB 101 is required. Another new option we've created for this year is that generally renewal applicants are going to need to do this, but they may provide a previous year form if all the information is still accurate. Okay. So we'll talk through your licensing process. This is the exact process that's lined up and established in publication 309. So if you're looking for a more in-depth explanation of the licensing process, we highly encourage you to check out publication 309 provided by the division. And the steps are relatively straightforward. The first thing that kicks off the licensing process is you're going to receive a complete application packet. The information that I have listed here on this slide is really about maximum exposure. This is all of the requirements of perhaps a brand new initial applicant under state law. Your municipality may have other requirements that you ask people to provide, like a business plan or other information that you ask for at either initial application or renewal. That's not going to be included here because I can only speak to state law. And then also if you're renewing a license, we've talked about, you know, a renewal applicant does not need to provide proof of RBS course completion because renewing a license automatically includes them in having completed that requirement for their license purposes. It is generally up to you all as clerks and the licensee to know what is required and what isn't at renewal time. The one thing I will say is that you should ensure every year that you're getting an updated proof of seller's permit from your licensees. After you've received your complete application packet, that's when your waiting period begins. Your waiting period begins 15 days from the date of application, unless otherwise established by ordinance. Temporary licenses have options to establish an alternative waiting period, and there are some municipalities in Milwaukee County that can establish an alternative waiting period. But for the most part, statewide, the waiting period for a license application is 15 days. While that waiting period is going on, you're going to want to publish relevant application material in the newspaper. You can check out publication 309 part 7 for details about what should be published. And generally the division recommends that you publish in the newspaper 5 to 7 days prior to the governing body action on it. So be it your licensing committee meeting, the actual governing body vote, it should be roughly 5 to 7 days before any of that action takes place so that the public has adequate notification to consider these applications and the renewals in their community and decide to show up at the meeting if they want to. After publication, the governing body makes a decision. They will decide to approve or deny a license application. And then the reason for denial should be noted in the meeting minutes if they are going to deny. After the governing body has made a decision to approve the license, that's when your license fee is collected. When I say license fee, I mean the $500 for the Class B liquor, the regular Class B liquor license, or the $10,000 if that's a reserve liquor license. That is the fee that's going to be established in your municipal ordinances and confined by the parameters of state law. There are specific restrictions in state law about when a municipality can collect the license fee, and it is certainly not at the very beginning, and we would highly discourage you from collecting license fees at the time that you receive an application packet, because there's a lot of things that can occur in between receiving an application packet and the license actually being issued that can cause problems. Finally, once the fee is paid, the clerk can issue a license certificate document. And again, we will encourage you to see publication 309 part 7 for the information that should be included on a license certificate. The next slide here is just about who grants an alcohol beverage license. A governing body needs to grant all of the regular Class A, Class B, and Class C licenses. a governing body may delegate authority via ordinance to an official or body of the municipality to issue temporary alcohol beverage licenses. And certainly we've had some questions recently about provisional licenses. If you don't have ordinances related to provisional licenses and who must issue them and under what circumstances, those ordinances are required under state law. So we would highly encourage you to consider your municipal ordinances as it relates to provisional licenses. If you issue regular licenses, you are compelled by state law to issue provisional licenses, but you can set the terms under which that happens, and you do so via ordinance. So please keep that in mind. Okay, with that, we're going to move into our updates. So we're going to talk first about AB 200 since that is the largest amount of change that we've experienced for this licensing season. We have been asked since 2023 for a simplified renewal path, and AB 200 for 2026 accomplishes that end. I know we heard a lot of feedback that the timing wasn't ideal, and we agree. We worked really hard to try to get these forms out as soon as possible. Our goal was to try to have these out in advance of everybody sending out application packets, but it just did not work out the way we needed it to. There was a little bit of implementation that we had left for the laws that became effective on January 1st that really prevented us from digging into the licensing forms as we wanted to. So it is what it is, unfortunately, and we did want to uplift and acknowledge that the timing wasn't great. And we do apologize to all of you who had sent out packets for that. Our goal for next year is that we are going to provide updated forms or notification that forms aren't changing by January 2027, so we don't continue to run into this issue. Now, we have to caveat for legislative changes and any other law implementation that we would have to do at that time. But theoretically, the new legislative session won't be starting again until that point. So hopefully, we will be able to be on time this year. I'm really optimistic. I wanted to shout out the League of Wisconsin Municipalities and the Towns Association. They did provide us some feedback and some support as we were creating the updates for these forms. The staff over there was great. They gave us some great feedback and helped us determine a good path that would hopefully work for most municipalities. And certainly, I would say we have moved the application instructions to the beginning of each form. They are intentionally very robust. There's a lot of information in the instructions. So please rely on them as you're interacting with licensees, as you're trying to understand these forms themselves. Certainly, we create these with the goal of making them clear and user-friendly. If you still have questions, you're obviously welcome to interact with us and reach out to us to get clarity. But they are very comprehensive, and we tried really hard to make sure that you could rely on those instructions and that they would be complete and useful. So if your application packets already went out, which is the case for many of you, you can decide which version of the paperwork you would like to accept. The reason is because the applications are required to be complete under both systems. Licensees are not getting out of providing AB 100 and AB 101 at all. They are just allowed to provide the most accurate version of those documents. If you're using the 2025 version, technically they are supposed to be doing it new every single time. So the packets have to be complete. I would say the biggest loss is if you didn't wait until the 2026 packets went out, licensees may have missed out on providing a few less forms at renewal. They may have just missed out on or started the process to get their officers and directors, for example, to sign new AB 100s and 101s. I will note, we have heard and seen some municipalities using very dated forms. AB 200, AB 220, AB 101, and AB 100 are the alcohol beverage license application forms that are provided by the state. Anything that is older than that is discontinued and not appropriate for use. The biggest thing is that Act 73 went into effect in beginning in 2024. So those forms that even were created in 2023 are going to be dated. So please be sure that you're linking and connecting with the most updated forms provided by the state. Okay, what does complete paperwork mean, right? I said you could accept either version of the application packets, either from 2025 or from 2026, because complete paperwork is required. For the 2025 version of the paperwork, this means you have an AB 200, you have AB 101s for all individuals involved in the applicant business, and you also have an AB 101 for a corporation or LLC. If you're doing this by the book and as the instructions required, licensees were required to provide all of that paperwork new to you every single year. In 2026, complete application packets from licensees are still required. You still need AB 200 for either a renewal applicant or a new applicant. If you are a new applicant, you still need an AB 100 and you still need an AB 101 if you're a corporation or an LLC. That hasn't really changed from the 2025 version. It just looks a little bit different, the way that they would indicate each person that's involved in their business. The biggest change is that renewal applicants have an option to essentially not have to provide updated AB 100 or AB 101s every single year. As long as that paperwork is the most accurate copy, meaning the information on AB 100 or the information on AB 101 hasn't changed from the previous year, they can provide a copy of that paperwork from last year in order to complete their application for 2026. Most accurate. So again, the most accurate version of AB 100 or AB 101 is due every year in a renewal application. This is really about ensuring that the licensee needs to do their due diligence to ensure that the old paperwork is still accurate. If there are circumstances that have changed, like a member or a manager of an LLC has moved, for example, that's information that's collected on AB 100, and that individual would need to do a new form in order to confirm that you have the most accurate copy. It just lessens the burden, particularly on larger businesses that have a lot of members, managers, officers, and directors, that they don't have to do this new every single year, provided that the information collected on AB 100 and AB 101 hasn't changed. So we have a couple of examples that will hopefully illuminate this for you and make it a little bit more obvious about what is required every year. So in the first example, we have an LLC that is renewing their Class B combo license since 2023. There are 3 members, and one of the members is also considered the agent. For this license year, in this example, no information about the LLC, nor the information requested on the 3 members' AB 100s has changed since 2023. This means that they will be able to turn in an AB 200 for the LLC, and they can turn in 3 AB 100s and 1 AB 101 from last licensing year, because all of that paperwork is still accurate. So in this instance, this process is saving these 3 people from having to do essentially 3 brand new forms when they most likely have that paperwork on file from last year. Next example, same LLC, same 3 members, an agent. This year, one of the members left, Kathy. That means that at this point, this is just a straightforward, a person left the LLC, they're no longer participating in the business. That means that the other two remaining members and the agent are still intact. They can still provide their AB 100s and AB 101s from 2025, but they do need to update the AB 200 appendix to indicate that this person is no longer a part of the applicant business, that this third LLC member has left. The third example we have here, again, same LLC, 3 members, and one of the members is an agent. We have the agent and one of the members of the LLC leaving, and then a new member joining in 2026. So the 2 remaining members may turn in their AB 100s from 2025 licensing year. The new member of the LLC needs to turn in a new AB 100. And because the person that left was their agent, they need to appoint a new agent using AB 101. They also need to update AB 200 Appendix A as appropriate. Okay. One of the other big changes that you'll see on the application forms on AB 200 is about, we've rephrased the question related to upstream entity ownership. And this is historically a very tough question for us to be concise about, especially as it relates to creating like a yes or no question on an application and then coming up with some sort of instruction that matches. So really the purpose of this question to evaluate the upstream entity ownership is because there needs to be people who qualify to hold an alcohol beverage license under state law. In the event that a business is owned by another business, we need to consider the upstream ownership chain until we can effectively identify the people who are making decisions of that business and who are in control of that entity, because they need to qualify under 125045 in order to hold that license under state law. So we tried to update this question to be more specific about when the entire ownership structure needs to be evaluated for license qualification purposes. And this is a copy of the question and how it's rephrased. It's part A, question 6, and then the language below here is the instructions. I think understanding this, core to understanding the upstream entity ownership question is understanding entity structure, period, which is easier said than done. And, you know, some staff at the division have attended many alcohol beverage licensing related and industry conferences, and there are no states that do this perfectly, just because entity structure is always changing. It's governed by a totally separate set of statutes. And there's a lot of other implications for businesses outside of alcohol beverage licensing. This is about taxes. It's about, a lot of the time it's about taxes, but it's essentially about your core business structure, and alcohol beverage licensing is not always core to that. We're talking about a subset of businesses, so it's difficult to regulate. So generally, when we're talking about a sole proprietor, that's an individual person, and that's an owner. So that business is essentially controlled by a person, the sole proprietor or the owner. When we're talking about a partnership, a partnership is a business entity, but it is controlled by partners who are people. A corporation is also a business entity. You'll see if something is called incorporated, that's a corporation. And the people in charge of that corporation are called officers and directors. Those are also, excuse me, always people. Finally, we get to limited liability companies. And who is in charge of a limited liability company could be members or managers. That's what the title of those folks are called. In the case of sole proprietors, partners, officers, and directors, those are all required to be people, humans, which means that we have a spot for alcohol beverage licensing to go and say, these people are the decision makers of this entity, of this business. they are the ones who are responsible. They're the ones who have to qualify. The reason why we updated the question in Part A, question 6, to specifically talk about LLCs and if the business is an LLC, is that members or managers of an LLC can be other business entities, which means that oftentimes it's an LLC that could be owned by another corporation. It could be owned by more people. That's really the specific instance in which we need to think more closely about that business entity structure and make sure that we're evaluating the entire ownership chain until we get to people. So hopefully this background is more helpful to you in understanding this. I certainly understand too that the extent to which you have to deal with complicated ownership chains is going to depend a lot on the types of businesses that are in your community. This is something that as you're implementing this or as you're having licensees fill this out, if there's a lot of confusion, we would certainly love to advise and help you out as best we can on this. It's a really tough law to understand, and it's tough to apply these, what feels like totally separate, unrelated concepts about what type of business entity you are to alcohol beverage law. And it's difficult because no state does it perfectly. So hopefully this background helps you understand more, at least the purpose of the question, and can help advise your licensees a bit better. Hey, Part C was another element of AB 200 we changed relatively significantly. There is no longer a table in Part C itself of AB 200 to list persons because it was replaced with Appendix A. We wanted to be sure, though, that licensees understood that they still have a requirement to get paperwork, supplemental paperwork to you in order to complete their applications. So essentially, we've restructured this section as essentially an attestation. I understand that I've provided and listed the personal information for all the people involved in my business, that they have provided accurate forms for all the people in AB identified in the table. If they're a corporation, an LLC, or a nonprofit, they need to provide AB 101, most accurate version. And then also checking that they understand that the application is not complete until the supplementary paperwork is received. Okay, Appendix A. Give me 1 second here. Appendix A replaces the list that was in Part C in prior forms. And this should be used for both new and renewal applicants. Every year, you need to get an updated list of individuals involved in the applicant business for alcohol beverage license purposes. There's an option to check new or renewal up at the top. And essentially, it just collects first, middle, and last name of those people, their title or relationship to the applicant business, contact information, and then there's a status to provide whether or not these people are new, whether they've been removed, whether they've been updated, or if there's no change related to those folks. For new applicants using AB 200, not a lot has changed except not a lot has changed about the information we're collecting, except for the format in which we are collecting it. So new applicants are going to use Appendix A of AB 200, and all of the entries on a new initial application are going to be marked new. And all of those people are going to have to provide AB 100, and if they're a corporation or LLC, they'll need to provide AB 101 for their agent. So pretty straightforward, new applications, everybody's marked new. Note that AB 200 Appendix A is a fillable PDF, and the status column, if you are using it in fillable PDF form, has these statuses pre-programmed. So we have the status definitions on the form itself so that if you are still using printed documents, people will understand that these are the 4 statuses that are appropriate for this section. But I would like to highlight that all of our applications are fillable PDFs, and they it's really helpful because it's going to promote more standardization and you don't have to worry about handwriting as much. So status is here. And on a new application, everybody will be marked new. Pretty straightforward. The renewal path is a bit more, is different, but hopefully it's abbreviated in the experience is that it's less burdensome in terms of paperwork for licensees and for clerks. So if you're a renewal applicant using AB 200, you'll follow the renewal path. It's right up at the top to check new or renewal. We have adjusted the premises description so that renewal applicants do not have to write out their premises description every year. And that's because we have seen instances in which municipalities or licensees have not used the exact language on their renewal applications from the year prior or from their license certificate document, which means that their premises description could change slightly from year to year. And in some instances, that could have significant consequence. It's important that when a municipal governing body is voting on a license, the premises needs to be acceptable. And if there is an assumption that the premises is the same from year to year, but it's actually not, they could be voting on something that they actually don't approve of. And it also could have consequences for licensees if they're not using the exact language. So essentially, if a renewal applicant checks the box that says that they're renewing the license, you would just use the same premises description that is found on their license certificate document so that it remains the same every single year. There are also instructions on AB 200 that if the licensee wanted to change their premises description, there's a way in which they would do that. And essentially they would not check the renewal box and they would describe the premises, which would be an indication to you as the clerk and to the governing body that there were some changes listed here. Okay, renewal applicants using AB 200. Every year, renewal applicants need to list all the persons involved in the applicant business in Appendix A, and they're going to use proper coding to identify if there are changes. If someone is leaving the applicant business, mark them as removed. If there are updates to the personal or contact information or the relationship to the applicant business, that person would be listed as update. And then if there are no changes, the relationship to the applicant business hasn't changed, there are no changes to the contact or personal information contained on AB 100 or AB 101, then those folks would be listed as no change. An AB 100 needs to be provided for anyone marked as new or update, because that indicates they are either new to the business and therefore don't have an AB 100, or that there are changes to the information in AB 100, so they needed an updated copy. And then for anyone marked as no change, a person can provide the most accurate copy of AB 100. So that could be an old version from 2025, for example, as long as all that information is the same, which they would indicate by saying no change. And then they also need to provide the most accurate copy of AB 101 for LLC or corporation applicants. Let's talk about records retention. License applications should arrive to the clerk complete, and there is an option in the instructions for the applicants to request old paperwork from you. You are not compelled to provide old paperwork. It is an option. And I'm certain that in some circumstances, you're just not going to have the time, the capacity to be able to provide that old paperwork, or for whatever reason, you may not have it. Licensees still have to do their due diligence. Ultimately, only the licensee can determine if the paperwork is accurate. So you can provide the old paperwork, but essentially the licensee has to determine that that paperwork is correct. And the onus in this instance for providing accurate paperwork is on the licensee ultimately. The reason why we wanted to be sure that the license application packets are complete every time is because municipalities have records retention requirements. You're supposed to keep all of the license applications, but you can destroy any applications over 4 years old. We certainly don't want you to be relying on, there are some businesses that have been established for a long time and could be in business for 15 years. And their original paperwork could be either dated or long destroyed. We don't want you to have to worry about destroying records per state statute if you're following your records retention guidelines as you're supposed to. And that is why we are still requiring the application packets to be complete with copies of old paperwork as the option that licensees can cut out having to do new paperwork every single time. We'll also say that there are, the onus is on the licensee, because if they are not providing accurate license applications, they're attesting that the information that they are providing the municipality is true and correct to the best of their knowledge. And if they're not providing accurate paperwork, there could be consequences to that. So that is why the onus is ultimately on the licensee to provide complete applications. Some reminders. Background checks. Licensees must meet the minimum statutory requirements to hold a retail or operator's license at renewal. So for retail licenses, it's every year. For operator's licenses, that could be a year or 2 years, depending on your ordinances. The only way that you can be certain that licensees are meeting their minimum statutory requirements to qualify every year is by conducting a criminal history check. So you have to engage in that every single year, including at renewal. How do you do one? There are a couple of different options. I would say you can look to your local law enforcement agency for support, your local PD or county sheriff. I know this isn't always going to be an option. Those agencies tend to be really busy and don't necessarily always have the staff to be able to do this, but if that's a resource you can lean on for this purpose, highly recommend it. They're going to probably have access to the most complete records because they're a law enforcement agency. The next place you can look at is CCAP, Wisconsin Circuit Court Access website. CCAP, this is free, but the records are not necessarily complete or fully updated. So approach that with caution. And I would say if you find anything in a CCAP record as you're looking through, it's probably worthwhile to do some sort of second check on this. The other option is to use the Wisconsin Department of Justice online record check system. These cost $7 per search. And this is actually the system that the Division of Alcohol Beverage uses for permit background checks. So this is one where anybody can use it. You just pay the $7 and you'll get the background check records. And they're pretty complete and generally reliable. Okay, we talked a little bit about at the beginning about arrest and conviction records being subject to Wisconsin Fair Employment Law. Wisconsin Fair Employment Law states that in order to consider arrest or conviction in a licensing decision, it must be substantially related to the licensed activity. So it has to be related. If someone has unrelated charges or unrelated criminal history on their record that's not related to alcohol beverage licensed activity or the requirements of being in that industry, it cannot be considered. Felonies are not cause to automatically deny a license. Fair Employment Law applies. And if a municipality refuses to license an individual due to a felony conviction, you have to give them the opportunity to show evidence of rehabilitation and fitness. So the biggest thing that I can say here is that at the division, we get a lot of questions about, is this sort of offense disqualifying? What about this? They've done, here's this person's criminal history. What do we do? The biggest thing that you can do is that you can talk to your municipal attorney about this. Your municipal attorney theoretically has had some experience with fair employment law. Again, it's the same thing about getting a job working for the government or working at a municipality. And you want to be sure that your licensing decisions are consistent with your own practice and state law. So speak to your municipal attorney if you come across these sorts of questions related to criminal history as it relates to licensing. If you're getting the most accurate version of forms, which means you have a renewal applicant that's providing forms and they're saying that nothing has changed about a person or their entity, you still need to do your background checks to ensure that that's accurate. Someone could have in the last year committed some sort of crime or engaged in some habitual law violation activity, and you need to do a background check every year to be sure that that's still accurate. If it is not accurate and the background check comes back with something different than the most recent application paperwork that they turned in, you should probably talk to your municipal attorney about what that looks like. There could be potential consequences to that, but it is one where, again, you want to be sure that your practice is consistent across your municipal government. And first, I would say reach out to your municipal attorney. And if you have more questions beyond that, certainly you can reach out to the division and we can advise as best we can. Application materials. State law does not require physical application materials be provided to the clerk for each applicant. You can download and email the forms and send them to your licensees. You can send links to the online forms on the division's website. You can create an online portal where applicants fill out their paperwork and submit it to you that way. Municipalities are required to use the state forms or a replica, and these are all acceptable options provided that the questions and all that information is consistent. You do not have to print things. I've heard of some municipalities literally bringing paperwork to their licensees every year. And while that is a wonderful service that is provided by that community, it is certainly not required. We also recommend that on your municipal website that you link to the forms instead of downloading them and then uploading them. The links for the division for the alcohol beverage forms haven't changed since 2023. So if you are downloading the paperwork and then re-uploading them, you risk having inaccurate paperwork because it's a downloaded copy instead of a link to the form. If you are linking to the form, you'll probably always have the most updated version if you link instead of upload. Couple of things on qualifying organizations and nonprofits as we're approaching the summer and festival season. A temporary licensee is still a licensee. Just like a bar or restaurant, they have to purchase from a wholesaler. They still need to have licensed operators supervising the sales and service. There are some nuances in some of these areas about the options the temporary licensees have, but there are also most regulations that still apply to temporary licensees as they do to regular licensees like bars, restaurants, liquor stores, etc. A nonprofit organization is and always has been considered a corporation for alcohol beverage license qualification purposes. There's been some confusion about AB 220. That form was created in 2023. And the only thing that changed there was, one, we updated the forms to be more comprehensive and include instructions and be very explicit about how these organizations needed to be treated. But for the most part, this hasn't changed. And if there were questions about requiring officers and directors of nonprofit organizations to still provide personal questionnaires and undergo background checks, if you would have called the Department of Revenue or the Division of Alcohol Beverages in that time before, we would have told you the same thing, which is that they're considered a corporation and they need to be qualified as a corporation. Also, being a nonprofit does not automatically mean the licensee is exempt from holding a seller's permit. The licensee needs to consult DOR's publication 206. That's relating to exemptions from sales tax. And if they have any questions about their sales tax obligations, they can call the DOR at the number on the screen and learn more and talk to someone who can help them determine whether or not they have a responsibility to collect sales tax. Seller's permits. Licensees are required to hold valid seller's permits per state law. Valid seller's permits begin with the prefix 456. And it is a best practice for clerks to request the licensee's seller's permit certificate every year. You can validate those certificates and those numbers on DOR's My Tax account. And there's also an article in DOR on Tap Fall 2025 that can walk you through validating seller's permit numbers and certificates using MTA. Last year, AT 827, which is your municipal license report, we added validation for the seller's permit numbers for the first time. They are going to be checked. The seller's permits are checked through the DOR's tax system to confirm that those seller's permits are valid. So if you have licensees that have really old numbers or have expired seller's permits, you're going to have a hard time getting your report submitted. So this year, if you can, please be sure to get updated seller's permit certificates if you're not already doing that as a practice. Couple things on the horizon, and then we will close up. The first, we are working through publication 309, and it should be posted, I'm hopeful, by the end of this week. That is your retail alcohol beverage licensing guide. We are not expecting significant changes, mostly just small additions for clarification purposes and just extra explanation and information. So again, no major changes to the spirit, the formatting, anything of that publication, just some changes, small changes in between. Publication 302 is getting a facelift. We are working through a major reformatting of the publication, and that is a process that we are working on in the coming months to add more clarity, comprehension, just make it a better guide for licensees to be able to rely on. The information in publication 302 at this point is still good. It's still accurate. So it is still the publication that you can provide, the packet that you can provide to your licensees per state law up until the new version comes out. So that is something that we're working on. Stay tuned. We are also working through temporary licensee specific guidance. We get a lot of questions every year statewide from municipalities who are, administering and issuing temporary Class B picnic licenses. And we recognize that this group of licensees is not deeply embedded in the industry. They may have one or two events every year, and they're just not as familiar with alcohol beverage laws and the obligations that they have. So we are working on specific guidance for that group, acknowledging that they're different. And it will have a similar look and feel to publication 302. It's going to be very comprehensive, hopefully. And we hope that that will be available no later than the beginning of 2027 licensing season. So early next year, coming soon. A quick reminder that if you have any qualifying event venue above quota licenses to issue, you need to do that by August 1st. So if you have any event venues in your community that have pursued qualifying event venue certification from the division, definitely make sure that your governing body is moving forward on those licenses, because they need to be issued by August 1st. And we have a couple of reports and communications. Form AT 827, your municipal license report, is going to roll over for 2026 in April. I don't know yet in April or when in April, but it will roll over in April. There will be communication that's sent out from both the Division of Alcohol Beverages and Tobacco Enforcement at DOR. We're going to send it through SLF's clerk listserv, which is, I'm sure, how many of you have come to find out about this opportunity. You'll get notified essentially when that rollover happens in April. Reports are due by July 15th per state law. We're not anticipating any major changes to that report form at this point. And you probably received a letter from the UW Survey Center maybe a month or so ago that DHS and the UW Survey Center are relying on the license data submitted through Form AT 827 to facilitate tobacco retailer compliance checks. So that's all going to happen through Form AT 827. So it is very important that if you have tobacco retailers in your area with CTV licenses, that you get those licenses put into Form AT827 to be sure that we can get DHS and the UW Survey Center the best statewide data available. If you're not sure you're getting our communications, be sure to make sure that your contact information is updated with state and local finance and your MyDOR.gov accounts. And you can also subscribe to the DOR's alcohol beverage and cigarette, tobacco, and electronic vaping device listservs from the alcohol beverage landing page via the button shown right below on the slide. A couple of questions we received. I will note that our pre-webinar survey was anonymous and we only selected questions specifically relating to licensing season. So if you submitted a question via our survey and didn't provide contact information, we would have followed up with you, but we didn't have contact information because the survey was anonymous. So if it wasn't answered here, you can reach out to the division via phone or email and get an answer. We had 2 questions. If we could create some printable versions of some older forms. No. Those forms were discontinued in 2023 or before, and they no longer reflect current law and administrative practices. So we are certainly not going to create printable versions of those. We highly encourage you to use the new forms that are available. And there was a request about updating AB 200 so that the $10,000 amount for a reserve license can show when it's printed. Our forms, all the alcohol beverage license forms, are designed as fillable PDFs. So if you type in those numbers on a computer, the font size will shrink and automatically adjust to fit the entered text. I think there are probably a lot of ways for municipalities to do this. If you wanted to do your updates and your administrative pieces on the forms and then give them to licensees printed in that way, you could do that. Otherwise, we highly encourage you to use the PDFs in the way that they were intended, which is to be filled in on a computer. And again, you don't have to worry about handwriting. You got better options to make sure things are spelled correctly. And certainly, as we talked about, Appendix A of AB 200 has specifically fillable forms sections that have pre-filled information to help keep your licensees more standard in their procedure when they're filling those out. So those are the 3. Some contact information is displayed on the screen. If you have any questions or need further clarification, you're always welcome to reach out to the Division of Alcohol Beverages using the contact information below. The very long URL is our website on the DOR website. So there's a ton of resources there, fact sheets, publications, all sorts of good information, and also where this recording is going to live when we finish it up and get it posted. I will say, when you're interacting with us, our email response time is currently 10 business days or less. And if we need a little bit longer to research your question or have to talk as a team in order to address, we are doing our best to communicate when our responses will take longer than 10 business days. We oftentimes get a lot of folks that will reach out to us multiple times or shop around for information, and that just sort of gums up our works and causes a delay in responses, or ultimately you get bad information. But if you have an urgent deadline, like you have a governing body meeting or something coming up, please let us know when you reach out in the original method, and we will do our best to get you the information that you need when you need it, so that we don't miss those important deadlines. So with that, so grateful that you could spend your morning with us. Thank you to all of you who joined us live here on the webinar. As I said, this will be posted on the DOR alcohol beverage landing page by Friday. And we're grateful for all of you that could be a live audience and join us here today. Thank you for your service to Wisconsin and to your communities. And I hope you have a happy and uneventful alcohol beverage licensing season and spring elections ahead. Thank you so much.